Canada's new law for refugees and asylum seekers means limiting access to refugee protection in Canada. On a brisk morning in February 2016, Ahmed, his pregnant wife, and their 2 toddlers got into a taxi in Buffalo, New York. "I want to go to the Canadian border," he told the driver. Their journey had begun 5 years earlier, when Ahmed and his wife attempted to flee Syria, in the run-up to the civil war. On their way to the Damascus airport, the couple was stopped at a checkpoint, where Ahmed, who had participated in opposition protests, was beaten by Syrian officials and forced to pay a $500 bribe in exchange for his and his family's release. They were able to live as temporary residents in Abu Dhabi until the UAE government unexpectedly expelled the family, in December 2015. Ahmed, who asked to be identified only by his middle name, knew that his life would be at risk if the family returned to Syria. Instead, they flew to New York on U.S. tourist visas. 2 days after landing at JFK Airport, Ahmed got a call from a Syrian friend in Canada, who told him that the new Prime Minister, Justin Trudeau, was welcoming Syrians. "Come to the border," he said. "They will accept you." What Ahmed didn't know, though, is that the few days his family had spent in the U.S., researching where they could get refugee status, would ultimately decide their fate. An agreement between the U.S. and Canada, called the Safe Third Country Agreement, STCA, prohibits most immigrants who pass through the U.S. from making a subsequent claim for asylum at a land border entry in Canada, and vice versa. The agreement, which was signed in 2002, is designed to prevent asylum shopping. Canada deems the U.S. safe as long as it maintains a good human rights record and complies with its obligations under accords stipulating that asylum seekers cannot be returned to countries where they may face persecution. At the Canadian border, where Ahmed's family was held for 12 hours, an officer told them, "I have to send you back to the U.S." Ahmed's wife screamed and collapsed. They spent the night sleeping on the floor of a jail cell in Buffalo. Following Trump's executive orders on immigration, in 2017 including a travel ban for several Muslim-majority countries, Canada reviewed its asylum agreement with the U.S. According to the Canadian press, which obtained documents under Canada's Access to Information Law, Canadian officials concluded that the U.S. continues to meet the requirements for designation as a safe third country. Last year, Trump began the practice of separating families at the U.S. Mexico border, as part of his zero-tolerance policy on illegal immigration. Trudeau was fiercely criticized for his initial silence on the issue, and legal experts again called for the government to suspend the STCA. A number of critics, including Nadia Abuzara, an associate professor of international development and global studies at the University of Ottawa, noted that Canada signed the agreement 2 months after the U.S. government deported a Canadian citizen, Mar Arar, to Syria, where he was subsequently tortured. Regarding the U.S. as safe for refugees, she told CTV News, was incorrect in 2002 and that assumption is now very visibly incorrect, with babies being taken away from their mothers and children being held in cages. A team of attorneys began the search for a federal court challenge. In the summer of 2017, Prasanna Balasundaram, an attorney with the University of Toronto's Downtown Legal Services, got a call from a client he was representing in immigration proceedings. The client's common-law partner had traveled from El Salvador with her 2 young daughters and arrived at the Fort Erie, Buffalo border crossing, hoping to join him in Toronto. But when she asked for asylum in Canada, claiming that she feared returning to El Salvador, where she had been raped and extorted by MS-13 gang members, officials told her she was ineligible. Because she had first entered the U.S., she was only allowed to seek asylum there. Balasundaram told me, "There was no doubt in my mind that these are people who truly face risk in El Salvador." Eventually, the woman and 2 other parties agreed to be litigants in a legal challenge to the STCA. It argues that continuing to designate the U.S. as safe violates Canada's Charter of Rights and Freedoms. The STCA was nearly overturned in 2007, when a federal judge ruled that the agreement was unconstitutional. in part because the US was not a safe third country for asylum seekers. There are the vagaries of US law which put women, particularly those subject to domestic violence, at real risk of return to their home country, the judge wrote. An appeals court, however, overturned the decision the following year, and the Supreme Court of Canada declined to hear the case. That was before the more recent changes in the U.S. Janet Dench, the executive director of the Canadian Council for Refugees, one of the applicants in the current case, told me. There's even more evidence the US is not safe, and many Canadians are watching in horror with what is happening in the U.S. In January 2018, an investigation in this magazine by Sarah Stillman documented the fates of women who are deported from the US despite expressing fears of returning to their countries of origin. I was a member of Stillman's research team, which recorded more than 60 cases of people who had been deported to gendered violence and death. The first screening of asylum seekers at the US border often falls to Customs and Border Protection officers, who are required to identify whether such migrants fear return. Stillman wrote, "My team and I heard stories from more than a dozen women who say that they were never asked the required questions, or were ignored, mocked, or even sexually propositioned by US agents after expressing their fears and then deported to harm." In June 2018, Jeff Sessions, who was then the Attorney General, issued a ruling that blocked asylum for victims of domestic violence. According to attorneys in the U.S. who shared a number of judicial decisions with The New Yorker, immigration judges routinely cited Sessions' opinion as the reason for denying a claim. In one case, a Salvadoran woman described her husband pouring hot coffee on her, threatening to kill her, and physically abusing her to the point of hospitalization. In another, a Honduran woman faced persistent sexual and physical abuse by her husband, who commandeered her children's documents and threatened to harm her if she went to the police. In yet another case, a Honduran woman's domestic partner kept her locked in her home and subjected her to repeated sexual assault. Sessions' opinion, which narrowed the definition of persecution to exclude non-governmental groups, including gangs, substantially reduced the rate of Central Americans granted asylum. According to Human Rights First, over the following 6 months, acceptance rates for people from Honduras, El Salvador, and Guatemala fell from 23.9% to 14.4%. Dench, at the Canadian Council for Refugees, thought that the ruling amounted to a nail in the coffin for the STCA. Karen Musilo, the director of the Center for Gender and Refugee Studies at the University of California's Hastings College of the Law, is an expert witness for the plaintiffs in the legal challenge to the STCA. During the government's cross-examination, she shared her concerns about the bullying, chilling effect on adjudication of Sessions' decision. "You have to look at what effect it has when the Attorney General is issuing a decision like this, and you have immigration judges who are basically the employees of the Attorney General," she told me. "He's sending a clear message that these cases are not to be granted." The Canadian government has been cross-examining witnesses since November 2018, and oral arguments could begin in May. In the meantime, the Trump administration has taken additional efforts to deter asylum claims in the U.S. In April, William Barr, who took over as Attorney General after the president fired Sessions, announced that asylum seekers in detention would not be granted bail until their cases were processed. A few weeks later, Trump ordered authorities to charge application fees to asylum seekers and to eliminate applicants' access to work permits. Even before these recent announcements, the litigants in the Canadian case had presented the court with mountains of expert evidence. Alex Nave, the Secretary General of Amnesty International Canada, told me. "The record of information in front of the court is a searing indictment. If a federal judge decides that deeming the U.S. safe is unconstitutional, Canada could stop sending people back to the U.S., effectively suspending the STCA." At the Burke's Family Residential Center, Ahmed's family was separated at night, by gender, into different cells. If one of their toddlers crawled into bed with one of them, the guards would separate them. In February 2016, Carol and Donahoe, an attorney who specializes in asylum law, learned of the family's case. When Donahoe met Ahmed, he was still clearly in shock, she wrote in an affidavit filed in the Canadian case. He was so horrified that he asked me if they could request being sent to Sudan because he'd heard Sudan accepts refugees. Ahmed told Donahoe he was afraid that if he applied for asylum he would be separated from his family and detained. Even during the Obama administration, Donahoe had seen mothers and children detained for up to a year, then transferred to the black hole of Berks. I tried to reassure him, Donahoe wrote, but I remember thinking, I don't know what this country is capable of doing anymore. She prepared a parole request, arguing that their detention was against policy directives and human decency. They were released after about 2 weeks and have been in court proceedings since. The family is currently living in New Jersey under temporary protected status. While they have provisional relief, Ahmed fears that Trump could revoke TPS for Syrians, as he has done for citizens of other countries. I started blaming myself, Ahmed told me. How could I bring my wife and kids to this place? In March, the STCA again appeared in Canadian headlines. The Trudeau government is approaching U.S. lawmakers to negotiate its expansion. The agreement doesn't currently apply to asylum seekers who cross through fields and forests, at unofficial entry points. Bill Blair, the border security minister, has vowed to close this loophole. His proposal would transport asylum seekers who cross irregularly to official entry points, where they would be denied entry under the STCA. Earlier this month, the Trudeau government buried new immigration measures into its nearly 400-page omnibus budget bill. A person who previously claimed asylum with one of Canada's Five Eyes intelligence allies Australia, Britain, New Zealand, and the U.S. is ineligible for protection in Canada. We're closing the border to everybody, Jenny Kwan, a member of parliament who has called for the suspension of the agreement, told me. It's not an actual wall, but, effectively, it means the same thing. Although Canada is celebrating a milestone, the 40th anniversary of Canada's private refugee sponsorship regime, which has resettled 327,000 refugees. But there are clouds on the horizon. Canadians most recently helped resettle thousands of Syrian refugees. Indeed, Prime Minister Justin Trudeau has welcomed refugees at our airports, and the government promoted Syrian resettlement with the hashtag #RefugeesWelcome. This celebration is in stark contrast to the federal government's omnibus budget bill tabled recently. Embedded in the 392-page document are troubling changes to our inland refugee determination system. Significantly, a new ground of ineligibility for protection is added to the Immigration and Refugee Protection Act. Claimants who have made a claim for refugee protection in another country will be ineligible to make a claim in Canada. That means many refugee claimants will be denied access to Canada without having an opportunity to tell their story and without having their claim heard by Canada's Immigration and Refugee Board. Some people may never be heard. Canada has an obligation under the Refugee Convention and the Convention Against Torture to not only treat all refugee claimants equally, but to hear them out. The Supreme Court of Canada held in the 1985 Singh decision that every refugee claimant has the right to be heard in an oral hearing. We celebrated this decision on its April 4th anniversary, now marked as Refugee Rights Day in Canada. Less than a week later, the government introduced a budget bill that tries to strip away that right. The government says we should be comforted by the fact that claimants will have access to a pre-removal risk assessment, PRRA, which examines whether someone would be returned to a situation of torture or other risk. But this isn't the same as a full hearing at the Immigration and Refugee Board. PRRA applications are paper-based, and an immigration officer conducts an interview only if the officer deems it necessary. And not all claimants will be told about the PRRA. Some people approaching our official ports of entry only get a PRRA when they ask for it. And even if they do know about it and get one, the acceptance rate is extremely low. 97% of all PRRA applications in 2018 were rejected. All Canadians would agree that we need to manage the border and the influx of migrants crossing it. But we shouldn't do that by slamming the door shut, violating people's charter and international rights, hoping that this will deter people. People are going to come to our borders no matter what the law says. Managing the border in an efficient and humanitarian way means allowing people to come to official ports of entry to be processed. We have a well-oiled system. Why turn our backs on it now? Our refugee determination system through the Immigration and Refugee Board is considered the gold standard all over the world. Let's use it. The government wants to turn back people who enter from safe countries such as the United States. But the U.S. refugee determination system is very different from Canada's. Former U.S. Attorney General Jeff Sessions issued a decision foreclosing people from making refugee claims based on domestic violence or gender-related persecution, for example. This denies protection to many people who would obtain protection in Canada. Children were separated from parents and put into detention in the U.S. People are being prosecuted for entering the U.S. outside of official ports of entry and are being detained while they wait for their refugee claims to be assessed. Why do we want to delegate our refugee determinations to a country that isn't respecting basic human rights of refugee claimants? We can't allow the Canadian government to use joyful images of deserving refugees arriving at airports and 40th anniversary celebrations to imply that only resettled refugees are legitimate. Doing good deeds through the resettlement program should not provide us with moral comfort in slackening our commitment to refugees who come across our borders. We should not focus on the route by which refugees come to us or how they ask us for protection. A refugee is a refugee. The Canadian government has introduced a bill in Parliament which expands the basis upon which people seeking refuge can be denied access to a hearing of their claim. This proposal has been widely condemned by refugee advocates as putting at risk refugees who need Canada's protection, simply because they have been entered into another country's refugee determination system. Understanding the motivation behind the proposed changes requires a brief understanding of the history of the Refugee Protection Division of the Immigration and Refugee Board, Canada's refugee decision-making tribunal. The Refugee Protection Division, RPD, of the Immigration and Refugee Board is a quasi-judicial tribunal which determines whether claimants meet the definition of a convention refugee or face risks described in the Convention Against Torture. It consists of quasi-judicial decision-makers who conduct hearings which guarantee procedural rights to claimants such as the right to counsel, opportunities to produce evidence and call witnesses, and rights of appeal against negative decisions. The RPD was established in response to a groundbreaking Supreme Court of Canada decision in 1985 known as Singh. The Singh decision is known for giving birth to the current refugee determination process in Canada. It found that whenever facts are in dispute and credibility is an issue in a refugee claim, a full oral hearing is required in order to meet the principles of fairness. The RPD's role is to comply with the standards set out by the Supreme Court in Singh. In its early days, the tribunal's proceedings resembled a court more than an administrative tribunal. Hearings were conducted by two decision-makers who had equal authority to accept a claim. Full disclosure of all of the government's evidence was provided to the claimant. Claimant's counsel was given the opportunity to define the issues and examine the claimant in chief. A non-adversarial refugee hearing officer was also present in hearings to ensure that all necessary evidence was placed before the decision-makers. As one of Canada's largest and most expensive administrative tribunals, the Refugee Protection Division has consistently been the subject of public debate. In particular, backlogs that develop before the RPD are criticized for enabling claimants to benefit from a lengthy stay in Canada and undermining the fairness of the system. These backlogs have developed when numbers of claimants entering the system have unexpectedly spiked. In response to these concerns, procedures before the RPD have been diluted. Decision makers have been reduced from 2 to 1, refugee hearing officers are no longer present during hearings, and claimants' counsel are no longer permitted to present the case first. These efforts have been aimed at increasing the efficiency of proceedings, effectively making the determination process faster. However, access to the RPD, the criteria that allows someone to go from making a claim to appearing before the RPD, hasn't been changed since the implementation of Canada's Immigration and Refugee Protection Act, IRPA, in 2002. Until now. From the beginning, access to the RPD for a hearing has never been assured. Section 101 of IRPA contains a list of factors that make a claimant ineligible to proceed to a hearing before the RPD. These factors include being refused refugee status in Canada previously, being a serious criminal or security threat, or traveling through a country that Canada has designated as being safe. Only the United States has been designated as such a safe country. Bill 97, the Budget Implementation Bill, proposes to add an additional ground of ineligibility to refugee claims. This ground of ineligibility will block access to RPD hearings for claimants who have made a refugee claim in a country with whom Canada has an information sharing agreement, currently the United States, the United Kingdom, Australia, and New Zealand. It will not matter if a person's claim has been refused or never decided in the other country. Simply making the claim will be sufficient to block access to a Canadian refugee hearing. These proposed changes have raised concerns for two reasons. First, it will be possible for Canada to refuse to hold a hearing for a refugee claimant who has never had a hearing. This appears to offend the principles laid out by the Supreme Court in Singh. Second, if the claimant has had a hearing in the other country and has been refused refugee status, Canada's refusal to grant a hearing is an implicit adoption of that decision. It is in some sense a reliance upon another country's standards for granting refugee status into our system. Ineligible claimants will have access to a pre-removal risk assessment, PRRA. The PRRA is a process designed for a quick administrative review of risks for a person on the cusp of removal from Canada. It is procedurally weaker to a RPD hearing because it is designed to be conducted in writing, in the absence of the person concerned, with decision-makers who are not subject to the decision-making standards of the RPD. The acceptance rate in PRRA applications has also been extremely low, approximately 3%, while the acceptance rate of RPD claims has fluctuated between 40 to 60%. The government's proposed changes will reduce the number of claimants and hearings before the RPD, reducing the tribunal's administrative burden. But it is feared that this ground of ineligibility will increase the risk that people who need Canada's protection will be returned to a place where they will face persecution or death. It is also the continuation of a worrying international trend toward offloading the responsibility for refugee determination. When Singh was being argued before the Supreme Court in 1985, the government tried to convince the court that oral hearings are not necessary to ensure fairness to refugees. It argued that the United Nations High Commissioner for Refugees approved of Canada's method of adjudicating refugee claims without hearings, and that many refugee-receiving countries processed claims in the same way. The government argued that a requirement to conduct oral hearings into every claim would impose a considerable strain on government resources. The Supreme Court found that these considerations were not appropriate when dealing with the guarantee of rights to refugees under Canada's Charter of Rights and Freedoms. As stated by Justice Bertha Wilson, certainly the guarantees of the Charter would be illusory if they could be ignored because it was administratively convenient to do so. No doubt considerable time and money can be saved by adopting administrative procedures which ignore the principles of fundamental justice, but such an argument, in my view, misses the point of the exercise under S1. The principles of natural justice and procedural fairness which have long been espoused by our courts, and the constitutional entrenchment of the principles of fundamental justice in S7, implicitly recognize that a balance of administrative convenience does not override the need to adhere to these principles. The proposed changes, if passed, will pose a challenge to these principles. Amnesty International is sounding the alarm over the Trudeau government's tougher line on asylum seekers, saying Canada risks its global reputation as a welcoming place for refugees and would become another country to close its border to the world's most vulnerable if it changed its asylum policy. Erica Guevara-Rosas, Amnesty International's Americas director, is in Ottawa this week meeting with senior government officials, including Border Security Minister Bill Blair, to discuss the surge in asylum seekers at the Canada-US land border and other human rights issues in the hemisphere. She said the NGO is worried about the Trudeau government's shift in refugee policy as it looks to stem the flow of asylum seekers between official points of entry. It would be very concerning that a country like Canada, particularly, the government of Prime Minister Justin Trudeau, makes this kind of dramatic shift into becoming a more restrictive, conservative policy that is denying the rights of people to seek asylum in Canada, Ms. Guevara-Rosa said in an interview. Amnesty International Canada Secretary-General Alex Nave said the use of inflammatory language by the Tories and Maxime Bernier's People's Party has stoked fears of an invasion of illegals at the border and caused the Liberal government to rethink its asylum policy. There are political parties that have been fanning the flames around this. The hardening of attitudes around refugees and migrants has propelled the government to pivot a little bit, Mr. Nave said. The Liberal government has also proposed changes that would prevent asylum seekers who have already made a refugee claim in the United States, Britain, Australia, or New Zealand from having access to a full refugee hearing by an independent tribunal. Amnesty and other refugee advocates said the proposal, buried in the omnibus budget bill earlier this month, was as an attack on the rights of asylum seekers. The new provisions may run up against a Supreme Court ruling from 1985 that laid the foundations of refugee law in Canada. The Singh ruling found that all refugee claimants on Canadian soil are entitled to an oral hearing.